The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Good afternoon. Please be seated. The case of State of Iowa versus James Vandermark is hereby submitted without oral argument. And this afternoon, our first case for oral argument is State of Iowa versus Michael Montgomery. Mr. Jacobsma, you may go first.
Thank you. May it please the court, Counsel Soich. Mr. Montgomery has submitted 2 issues in his application for further review to this court, and I'm going to address the second issue that was submitted first. That issue being his request that this court find that the jury verdict in his case was inconsistent because the jury acquitted him of lascivious acts with a child, but found him guilty of sexual abuse in the 2nd degree. Now, to make that finding, this court will have to interpret Iowa's sexual abuse statute to require that a sex act be committed with some type of sexual motive, intent, or purpose. But for this court to do that, it has to do something that it doesn't do very often, and that is overturn prior precedent. Specifically, Mr. Montgomery is asking this court to overturn State versus Pearson because when Pearson announced its sexual in nature standard back in 1994, it made no requirement that a defendant act with sexual motive, intent, or purpose. And I would also like to point...
I recognize you. Your argument is Pearson was wrongly decided and had 2 fairly persuasive dissents. But has it been shown in the 27 years it's been on the books to be unworkable? What problems is it causing?
Well, the problem it's causing is, for example, what happened in Mr. Montgomery's case. The jury specifically asked for clarification on what is meant by sexual in nature, and the court didn't instruct it as well. And so I think that clearly shows that it's something that's not really workable, and it's, I think, just on its face, that standard is, of course, very vague and I believe unclear, and not something that a jury is able to work with very well.
What would happen to cases where there was a sexual contact just as a form of power or violence, but without a sexual motivation? Would those escape liability under the specific statute?
Well, I think if it can be proven that there's no sexual motivation, and it is strictly for some kind of power, or something like that. Now, I think, however, of course, modern day psychology and so forth has shown that sexual action, sexual motivation also feeds off of power. I think I talked about this in my reply brief that sexual motivation doesn't have to be the sole motivation for a person to act. Anger, power, exercising power, those kind of things can be also factors involved as well. So if at trial, certain acts are committed that contact is made with sexual organs, but it can be shown and proven there is no sexual motivation, yes, I would agree that under Iowa's sexual abuse statute, it wouldn't qualify as a sex abuse. Now, it could certainly qualify as some other criminal act, but not necessarily sex abuse.
What about the argument that the legislature knows how to require sexual gratification? It did so explicitly in other statutes, including lascivious acts, but not here, not in sex abuse. Was that omission intentional?
Well, I think it was, and I think the best explanation for that is that when the legislature enacted sexual abuse, the sexual abuse offense, it stated that a sexual abuse offense is committed when a person commits a sex act and under various circumstances. And then sex act is defined in section 702, which of course includes sexual contact and explains what it is. In statutes like lascivious acts, nowhere other than the one subsection that talks about soliciting a person to commit a sex act does the legislature say a person commits lascivious acts when they commit a sex act. What the legislature did was specified if they commit a certain act that has certain contact, then you also need the intent to sexually gratify oneself. So I believe what the best explanation is that the legislature, when they required that sexual abuse be committed, when a sex act be committed to be sexual abuse, that it was presumed or it was commonly understood that a sex act is something that requires sexual motivation, sexual intent, or purpose.
You may be right at the time, but it's been on the books 27 years. We assume they're aware of it. They amended that statute, tweaked a few other things recently without overruling Pearson. Doesn't the state have a good argument we should rely on legislative acquiescence, that if they thought we got their intent wrong, they would have overruled us with an amendment?
Well, certainly they could, have the power to make things more clear. But simply because the legislature hasn't acted to clarify a certain statute doesn't mean that it isn't being wrongly interpreted or applied by this court in the past, and doesn't mean that this court shouldn't correct itself in correctly interpreting what the legislature intended. And that's where
Can I ask you about the inconsistent verdicts? In the Hallstatt case, we recognize compound inconsistency. How are these verdicts inconsistent within the meaning of existing case law to the extent we haven't recognized logical or factual inconsistency?
Well, I think that it's, to be inconsistent, I think the court would have to abandon the sexual nature standard and require the sexual motive or intent be required to be a sex act. Because I think if that's the case, then essentially lascivious acts and sexual abuse, in this case at least, were virtually identical other than the issues with the age.
But they're not compound inconsistent within the meaning of Hallstatt. Would you agree with that?
They're not compound in that you don't have to commit one in order to commit the other.
Right. And
Think
the
like
case law
Hallstatt
indicates that whether this is true is a factual matter. At least we assume that in these instances, maybe the jury exercised lenity to acquit on one of the charges here, lascivious acts. So explain to me again how these are, or how you think they're inconsistent within the meaning of the case law.
Well, I think that if you look at the evidence in the case, even if one takes the sexual in nature standard that's set forth in Pearson, I mean, clearly because the jury found him not guilty of lascivious acts, that means they couldn't have found that there was any intent to sexually gratify himself. I don't think any of the other circumstances that are set forth in those factors in Pearson are really present from the evidence in the case that would allow the jury to.
Would we have to then adopt some sort of factual or logical inconsistency doctrine in addition to our compound inconsistency doctrine?
Well, I think certainly logic is something that the court should employ, and when trying to interpret statutes and analyzing verdicts. I mean, obviously the jury is clothed with a great deal of power and discretion, but they have to follow the law, of course. And if it's illogical, then I don't think the verdict can stand either. Now, with respect to the sexual in nature standard, and as vague as it is, I think that when those list of factors were, those list of factors that are set forth in Pearson, okay, I guess what I would say, number one, to support that is I think Justice Snell said it best in his dissent. He stated that nothing in the definition of sex act in Section 702.17 in any way suggests that the legislature intended an outreach of this sort. I'm not sure how in Pearson the court was able to say that we're not going to strictly construe the statute because the legislative intent, we believe, is expressed and clear. And I don't understand how in Pearson the court could have found that, well, the legislature clearly intended that for a sex act to be committed, you didn't have to have sexual motive or intent. I just don't understand how the court may have found that to be something that's
Moving on to the rape shield issue, did the state at trials open the door to evidence of LV's, the teenage boy's abuse, by calling him as a trial witness for the state?
Well, I certainly think he did, and I think that obviously goes to the constitutional right to present a defense. Obviously, in the constitutional right to present a defense includes the right to effective cross-examination. Because of the court's ruling, the district court's ruling on this rape shield law issue, I mean, Mr. Montgomery was not allowed to question LV about his actions toward SV. He wasn't allowed to call the police officer to whom LV confessed these sexual acts to him as well. So yes, I do believe that the state opened the door by calling him as a witness in that case.
I have a follow-up to that, which is, I think it seems like that's a fairly compelling argument to me, but I'm struggling a little bit. The Holmes case from the U.S. Supreme Court, the court talks about the right to present a defense being limited by rules of evidence or non-arbitrary rules. So in this case, we at least have a public policy under the rape shield law of not allowing that kind of evidence. That seems to be a fairly compelling state interest. So how do we reconcile that, and at what point should this kind of evidence be allowed?
Well, I think, once again, it depends on what the purpose of seeking to offer the evidence is. For example, I think the real purpose of the rape shield law and that policy is to prevent a party from introducing that kind of evidence to simply malign the character of the victim somehow. But in this case, it was, of course, relevant to several different items that were crucial to Mr. Montgomery's defense. I mean, Mr. Montgomery defense being he didn't commit the acts, and the sexual abuse that she's talking about, it was a different perpetrator.
Does that just then collapse into a relevancy inquiry? I mean, if the evidence is relevant for some non, as you put it, disparaging purpose, then the defendant has an absolute right to put the evidence on?
Well, I think it depends on how relevant it is, of course. I mean, and that
Counsel, on that point, can you clarify the record for me? What does the record show that the victim claims was the last, the timing of it? What was the last time that the defendant was alleged to have inappropriately touched her?
That the defendant did? I think I would have to check on that, Your Honor. I think it was several months before she went to the Child Advocacy Center interview.
And that was where my question was going. So in May of 2018, the offer of proof shows that LV had engaged in some activity just within days before that. Is that
that is correct? Accurate? Yes.
Okay. And I guess related to that then is that then the nurse was able to testify only about what the defendant did, but not about, or what the victim told the nurse about what the defendant did, but not what LV did. Is that correct?
That's correct. Yes, it is. And that also goes to the issue of the source of knowledge of LV's description. I mean, one thing she was specifically asked was, how Mr. Montgomery's genitals actually felt. And now the Court of Appeals kind of explained that away by saying the evidence also showed she was exposed to pornography. But by describing how it felt, of course, I don't think simply viewing pornography would have been able to allow her to do that. So there's other case law that I cited to the court in my brief from other jurisdictions that have held the same thing, that under the U.S. Supreme Court case of Davis versus Alaska, that rape shield laws do have to give way to a defendant's right to offer a defense in those kind of situations. And in fact, there's another case as well that I didn't cite in the brief that I just wanted to bring to the court's attention that did also specifically hold that. It's from the Supreme Court of Pennsylvania. It's Commonwealth versus Black, and it's at 487 Atlantic 2nd, 396. It's a 1985 case as well, but specifically reversed a conviction under the rape shield law under Davis versus Alaska as well. I see my time has expired. Thank you.
Thank you. Ms. Soich?
Good afternoon. May it please the court. Your Honors, my name is Soich, and I represent the state. We're here today asking you to affirm Michael Montgomery's conviction for second-degree sex abuse. I, too, would like to take the order of kind of the macro issue first in terms of should this court overrule Pearson, and then move to the rape shield issue. Your Honors, this court should not overrule Pearson. Pearson was correctly decided at the time. As the court knows, the legislature is its own lexicographer, and the legislature has been very clear in stating that they're not having any specific intent element in sex abuse. And this court has been very clear from the 80s in the Sullivan case and the Tague case, all the way up to a couple of years ago in the Kelso-Christie case. This court, Your Honors, has time and time again stated sexual abuse is a general intent crime. The legislature would certainly know how to make it a specific intent crime if they had wanted to. They didn't. It's a general intent crime. And there really shouldn't be much room for argument, I think, on that point. Pearson was sort of an interesting case, obviously coming down the same day as Monk, which was a really interesting case, factually, about what is a sex act? How do we make sure that innocent behavior is not sort of swept in to the sex abuse laws? And I think that in one of the most memorable lines ever written in Iowa appellate writing, Justice Carter says, "I believe it is axiomatic that anytime two persons are moving about in close proximity, innocent conduct may occur between sexual parts." So that's in a kind of partial dissent, partial concurrence, but the point is he's trying to get at what about the accidental contact, or what about contact that is somehow otherwise innocent. In Pearson, we talked a great deal about the department store Santa Claus, because in Pearson, as the court will recall, we had a defendant who was clothed, at least for one of the counts, having a young boy sit on his lap facing the same way in a truck, clothed, and he sort of moved the young boy over his lap. So he argued that means anybody bouncing a child on their lap is guilty of sex abuse. That can't be right. So the court in Pearson, Your Honors, was, I think, very wise to come up with a way in which we judge whether contact is sexual or not, while at the same time not adding an element to the offense. And to be clear, you would have to rewrite this statute if you hold that there's a specific intent element or an element of sexual gratification or arousal. It's just not there, Your Honors. And
can we focus on the one incident in which Montgomery states that the child placed his hand on her genitals, he pulled it away, and then she did it again, he pulled it away, and I think they sent her out of the room or something. I take it the state's position is that that would be sufficient evidence of a sex act under Pearson, and I guess I'm questioning why, because that seems to me to be non-volitional, maybe, and more akin to what Justice Carter was talking about in some sense.
Your Honor, yes. I think that you could make the argument, certainly, that that was non-volitional. So if the jury was focusing on that one incident where the defendant says, twice she grabbed my hand and put it on her vagina or in between her legs, I think a defendant would have a very good argument to say the general intent requires that I at least do a voluntary or volitional act. This was not in any way voluntary or volitional. I did not intend to even make that contact. So the state doesn't have to rely on that in terms of the sex abuse. And I want to just clear up for the court, in terms of the inconsistent verdicts.
Well, and this is kind of a follow-up to, I think, or maybe it's a lead-in to where I think you're going. But if you look at the jury's verdict and you look at the testimony, it seems like what happened, at least to me, if I'm reading the tea leaves, is the jury may not have believed anything occurred other than this act, which is how you would square the acquittal on lascivious acts with the sex abuse conviction, coupled with their request to the judge, we'd like more instruction on this charge. I don't know. That seems to make sense to me, but I just wanted to say that because I assume you're going to say there was a lot of testimony about other acts, and I understand that.
I am, Your Honor. And I think this court recognized in Halstead, we were not going to open up a Pandora's box of trying to look at what exactly the jury was looking at when it returned its verdicts. And again, especially here when we have different acts, and we do have hand-to-genital contact involving his penis, hand-to-genital contact involving her vagina, we have oral sex allegations, we have allegations that she was made to sit on top of the defendant while naked. We have her testimony, the victim's testimony, that this happened probably monthly for a matter of 18 months or so. So again, we don't have to kind of get into all the particulars, and indeed it would probably be very difficult to get into all the particulars of exactly what the jury was focusing on. They could have found the oral sex allegation to be the most credible. They could have found one of the hand-to-genital contacts to be the most credible. We simply don't know. And we don't, again, with all due respect, we don't need to know because the jury is able to believe some, all, or none of each witness's testimony. And the fact that they, in this case, acquitted on one count, and again, these aren't counts that are predicate counts or lesser included offenses in any way. We just allow the jury to do.
But in this case, we would have to believe, I mean, either the jury just exercised lenity and decided not to convict on lascivious acts, other than the touching of her, the non-volitional act in the bedroom. Any of the other allegations would be more than sufficient to prove lascivious acts. Each one standing alone. This is the only one that would not be sufficient to prove lascivious acts, but would be sufficient, maybe, to prove sex abuse.
And the Court of Appeals, I think, Your Honor, said that they thought that with regard to the specific act of the defendant's claim that she grabbed his hand, twice, the Court of Appeals points out this is a 7-year-old child. This is a grandfather in his 60s. They're in bed together. She's able to somehow grab his hand twice and put it on her genitals. I think that the Court of Appeals thought that really strained credulity to even assume that that's what happened, that a 60-some-year-old man could not stop a little girl from putting his hand on her genitals, and again, happens twice. So who knows, Your Honors, what exactly the jury was wrestling
Noting that
with.
age difference, does it strain credulity to think that she would mix up what happened with LV, the teenager, and what happened between her and her grandfather?
Yes, Your Honor, I think it absolutely does. There was nothing really to indicate that she was mixing up these two events in her life. And I say events broadly because they obviously were both extended. But yes, you have her pseudo stepbrother who's 4.5 years older than she. They're at their house in the farm. There's a lot of kissing going on, it sounds like, for quite some time before things sort of escalate in May of 2018. And if I may just pivot for one moment to Justice Oxley's question, I think that my reading of the record is that the abuse with her grandfather, Michael Montgomery, stopped 2 years earlier. And I think in one of the forensic interview summaries or the interview with the sheriff, at some point she says that 2 years ago, May 2016, is when she made the outcry to her mother. Her mother, for various reasons, doesn't report it to the authorities, but gets her into counseling for a little while, then quits sending her daughter over. So 2016, by my reading of the record, is when the abuse stops with her grandfather. You are correct.
For clarifying that, because my problem, I guess, is my question for you then related to that is, did the defense, separate from confusing who was doing the activity, did the defense raise an issue of whether or not she had a motive to try and hide that the activity was really with the stepbrother?
Yes, Your Honor. The defense raised that. I think the defense has raised it sort of more clearly as we've gotten along in the process. But so I think it has evolved a bit. But in front of the trial court, the first issue was she was confusing the two. And then the second issue may be a little bit of a suggestion of this will show how she has knowledge of sex, age-inappropriate sexual knowledge. But then there was this idea also raised slightly at the trial level, and again, I think honed in more now, that she had this motive or bias. And what I would love the court to focus on in this context is that this is not one of those cases where she's found out. Let's say she's sort of outed, for a better word, in terms of the sex abuse. And because of a pregnancy or an injury, or someone reads her diary, or someone hears her making a claim that she was sexually abused, and then she has to sort of give up a suspect to the authorities, and she says, well, it was my grandfather, because she wants to protect her stepbrother. That's not what we have here, Your Honor. So we don't really have the factual predicate that we see in a lot of these cases. In the DeLawler case, I think, the young girl's 13, she's pregnant, she has a very strict mother who doesn't allow her to date and beats her.
So how much evidence would the defendant need to have to be able to use the motive as a basis to get past the rape shield, I guess would be my question.
Yeah, I think you would have to have some evidence, Your Honor, that it actually exonerated him or had the potential to exonerate him, or at least show a very serious bias in order to justify piercing the rape shield.
Why wasn't the expert witnesses' offer and potential testimony sufficient to satisfy that threshold? This is not a case where, and you've seen them, where the defendant just wants to point the finger at a third person, but then there's nobody to connect the dots for the jury. Here we have an expert. Everything you're talking about seems to me to go to the weight given to that expert's testimony, not admissibility.
Your Honor, I don't think the trial court really believed this expert, because this expert simply said children can mix things up. Children can mix up.
I understand that, but isn't that a jury function? I mean,
well,
we've seen lots of cases where there are non-credible experts that their testimony is put into evidence because their method satisfies the Daubert standard for admissibility, or the state standard.
And Your Honor, this expert was able to testify that children do mix things up. She just wasn't able to testify, as the defendant wanted her to, that, and she actually came right out in her offer of proof testimony and said, I believe she's mixing up the testimony about LV and kind of putting it over into the testimony or to her belief of what happened with her grandfather. She was able, though, to testify that children mix things up, that pornography can make children sort of imagine things that don't really happen. But she was not able to testify that this particular victim was mixing things up, because, of course, that would have been a
But isn't that
Dudley.
the evidence that makes it relevant, truly relevant for the jury?
Your Honor, I don't think so. I think that would have been a straight-up Dudley violation.
I mean, it's like you said 10 minutes ago, Ms. Soich, that juries can buy some of the evidence, and often you have different versions presented at trial, and neither one is totally correct. Isn't it sufficient that these two abusers are engaging in, or two alleged abusers are engaging in their conduct toward the same person at the same time, and it's possible that even unconsciously or unknowingly, she put more emphasis on the older person than on the teenage stepbrother. I mean, isn't that possible? And it just seems like it's all one res gestae, and to kind of just present half of it to the jury is troubling.
But, Your Honor, in terms of res gestae, we obviously have the rape shield considerations to consider here, which have very weighty public policy reasons behind them that this court is well aware of.
I agree, and that's what makes it hard, yeah.
And in this case, again, I would dispute your characterization that it was at the same time, because again, I think that the grandfather's abuse stopped 2 years ago. She then told, LV, what had happened. LV says she told me before she told her mother back 2 years ago.
But so can I interrupt you for a second on this? So if it was 2 years before, and then she, I guess a piece of evidence that really bothered me was the fact that she went to the doctor. The nurse was able to testify, but the nurse was only able to, that this had just happened, and so, or that the child was being seen because something had just happened. But apparently it wasn't with the grandfather, according to the testimony, because that was 2 years before. And so the impression is given to the jury because she's only able to testify that the child identified the grandfather and the stepbrother, but the jury didn't hear and the stepbrother. And I guess that's where if you're going to talk about, bringing in all of the evidence or only only allowing part of the evidence, it seems very prejudicial that way.
Your Honor, may I have just a moment to?
Yes, because I have another question I want to ask after that.
Thank you. And Your Honor, I agree with you if the nurse had testified to anything substantive, if the nurse had found that there was any sort of injury to the hymen or any sort of genital bruising, anything like that, any physical evidence, then I think that would have been quite misleading, and that's how this whole
But she did testify, I believe, about trauma, right? And
she testified that often there is not trauma that is visible. In many cases, we don't see visible trauma. So there was no testimony of any semen injury or other physical evidence. So that's why it didn't come in. And for a while in this case, we talked about whether it comes in under that exception. But it wasn't misleading for the jury to hear that the nurse simply said normal exam, but that's not surprising.
Am I correct, and you can please correct me if I'm wrong, who called the stepbrother to testify?
I'm sorry, who called?
Who called the stepbrother?
I think the state did, Your Honor.
I think so too. Don't you think that's super weird? And then to have a rape shield, then hold up the rape shield when defense says, okay, we'd like to cross that guy.
I will say that it is a little unusual. I think that the court or the state called the stepbrother, if indeed, and I'm pretty sure they did, just to talk about kind of the other outcry. She had told her mother, she told her friend Addison, she told LV. He really wasn't much of an important witness.
Unless you're the defense.
Unless you're the defense, Your Honor. But there really is nothing that the stepbrother would have provided. And I'm sorry, I should not go on. I can see my time is up.
That's okay. Justice Waterman, I think, has a question.
What's the state's position on harmless error? If we are persuaded the rape shield ruling was erroneous and the cross-examination should have been allowed, is this harmless given LV's tangential role?
Yes, I think it is, Your Honor.
And can you elaborate on that anymore?
Well, LV in no way exonerated this defendant, because I think when you look at those cases where there is a constitutional requirement that something come in, like, for example, Chambers versus Mississippi, you have a murder, and then you have the court keeping out evidence that says someone else confessed to this murder. It's this person, not the defendant. As the court in Chambers calls it, directly relevant evidence on the ascertainment of guilt. It was him, not me. Here, there was no sort of, it was him, not me. It may be, it was both of us, but there wasn't one act which would have made a difference. And if I might just have the court's indulgence to just point you to one case, Your Honors, that might help.
You may wrap up.
Not in the briefs, I'm sorry, but the Stamper case in 2002 is Iowa Court of Appeals case. And in that case, we have a sex abuse where a defendant is in a room, they're remodeling a house, he's a family friend, and he and the 7-year-old victim and the girl's father and others are all in a room together at night. It's dark. She's sexually abused. It comes up later in the context of newly discovered evidence, but he actually finds out later that the father, who was in the same room in the dark, was suspected of sexually abusing the daughter as well. So I think when you have that sort of evidence where it is really sort of an exoneration, somebody else may have done this. The court in Stamper, they also talked about knowledge of the victim, but I think the primary thing in Stamper was they said this could have really been important evidence to show that the father did it rather than the defendant. Thank you, Your Honor.
Thank you. Mr. Jacobsma?
Thank you. I guess going first to some of the issues raised by Justice Oxley, as far as when the alleged abuse had occurred, I think the testimony in the record shows that SV's testimony, she was very equivocal, kind of all over the map as to when that started, giving various different times as to when that began. Now, with respect to the bias that SV showed and the evidence for that, I mean, I think there was more as well than just simply, I mean, she clearly in the interview to the child advocacy worker, I mean, she was, number one, saying how she felt really bad about getting her brother in trouble. She also stated to the interviewer that, well, I told LV that my grandpa was abusing me, and I think that's why he started doing it as well. So she's clearly trying to cast blame on him as well. So that clearly shows, I think, a bias that she would have against him. With respect to the issues that were discussed about the expert, Dr. Thurman, Dr. Thurman also testified that LV engaged in grooming behavior upon SV as well. And so, I mean, so the comment or I think the argument by the state that, well, evidence of LV's abuse, isn't really like this huge kind of bomb that, would have really exonerated the defendant. I mean, I think it's not him, it's not me, but that certainly would have been the argument of the defense at the time had the evidence been allowed to be admitted.
Counsel, what about on the state's position that it didn't exonerate your defendant because your defendant admitted at least to the contact in the bedroom?
Right, but there again, I think that's where, I mean, certainly, he admitted to the contact in the bedroom, but it was not, of course, without any kind of intent, and it was, non-volitional. So now, then, but had the defendant been able to offer evidence that, well, LV was, abusing her, then certainly that could have was anything but harmless error. I mean, certainly the jury could have considered then that to be, something that's not sexual in nature, and that what she's really talking about here is the abuse that's being committed by LV, not her grandfather, and she's really just trying to blame her grandfather for it because she wants to continue to keep this relationship with her stepbrother.
Counsel, does it matter at all that the jury might be wondering how she knows the details that she's providing about the abuse that happened to her, and doesn't the stepbrother play into that too?
Well, certainly, because the abuse that she's experiencing from her stepbrother is, of course, how she knows about what sexual abuse acts are. And that, I think, goes to the source of knowledge that she has for the sexual abuse. Not simply, of course, being exposed to pornography, but she's being abused already by somebody, and that gives an explanation as to how she's able to describe this. I think that's a very important piece of evidence that, of course, the defendant was not allowed to present to the jury.
Can you help me understand the bias argument that would have been made at trial? She came forward and reported contact with both LV and Montgomery. Why would whatever happened between her and LV prompt her to make a false accusation against her grandfather?
To I think, try to mitigate the damage to LV. I think, as she explained, she didn't, she felt bad about trying to get him in trouble. I think she tried to give an explanation as to why he committed the acts against her because, well, she started telling him about what her grandpa did, and he thinks that's what prompted him to do it. And so I think that would have been the bias argument towards him. It was perhaps more of a bias in favor of her stepbrother, is that she, felt bad about reporting this and thought that, well, if she gives another abuser as well, particularly her grandfather, she can give some kind of explanation and not get him in as much trouble. I think that would have kind of been more of the argument.
You may wrap up.
Thank you.
Thank you. The case of State versus Montgomery is hereby submitted. We'll take a brief pause while the attorneys for State versus Allen get prepared.